Hello and good afternoon. I would like to welcome everyone to today's webinar, The Changing Landscape of Immigration in 2019. We have a great presentation ahead. Before we get there, I just want to go over a few housekeeping items. This webinar is being recorded, and everyone currently listening in will be sent a link to download the recording in addition to the slide deck after today's live session. We also encourage everyone listening in to ask some questions, and if you'd like to ask some questions, please do so using the question function that you see on the right-hand side of your screen, and we'll try to get to them after the main presentation has concluded. All right, now I would like to welcome today's presenter, Sarah Herbeck. Sarah is the managing partner at Global Immigration Associates, Envoy's affiliated law firm, and she is responsible for all legal services delivery. Sarah and her team work with clients to establish corporate immigration policies and procedures, along with training and educating clients through webinars and presentations to HR and talent acquisition teams to ensure immigration policies are applied consistently. Sarah, thank you for joining us this afternoon.
Thank you so much, Eric.
And for those that are unfamiliar with Envoy, for nearly 20 years, Envoy has been on a mission to fix the inefficient, frustrating, and confusing immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in 150 plus countries, has grown 46% year to date, and works with over 1,000 customers. Envoy is particularly proud of the NPS score, which is a testament to the employee experience we provide. All right, now I would like to go over a brief agenda in today's presentation. As you take a look at your screen, we'll go over the current talent landscape and then jump into some proposed policy overhauls in the last 2 years, provide a recap of 2017 to 2018, some USC trends with regards to RFEs, and then kind of look forward to this year. So with that, I'm going to also go over some learning objectives. As you take a look at your screen again, kind of recapping the last slide, and then the last point, really just kind of emphasizing that Envoy's goal is to help customers and foreign nationals by arming you with the facts. And with that, I'm going to turn it over to Sarah.
Good afternoon, everyone. This is Sarah Herbeck from Global Immigration Associates. Thank you so much for joining. We're going to kick this off with just discussing the hiring and retention of foreign national workers, specifically in the United States, and then also providing an understanding of what your employees' goals are or can be, and how that really impacts you. I think if we look overall at the numbers provided here, we're looking at mobility as being a general theme. We've got individuals who want to come to the United States and work. We also have U.S. workers who want to travel abroad and continue to work. And so there's a goal here of having a mobile workforce. And particularly when we're discussing that when it comes to the U.S. immigration context, there are quite a few items that you have to take into consideration, particularly under the current administration, that would have been potentially not necessarily a concern, but more of a how much do we want to invest question. And I think right now it's become not only how much do I want to invest in having this global mobile workforce, but also how much of a concern I should be. What concerns should I have out there? But considering the current administration's goal is to curb immigration and to disrupt the more stabilized environment of employment-based immigration in the United States. I think there are also some concerns, not only from an approval standpoint, but that extends to how am I going to hire and lawfully employ these individuals? So not only from an expense perspective, not only from USCIS is being more and more, have more and more scrutiny of what's going on and what's being filed, but how are we going to retain them? How are we going to effectively employ them? How are we going to have a workforce so that you can get the job done? So it's sort of a soup to nuts situation from a very nitty-gritty level to a very high level view of what's become important over the last several years. And I think that these numbers in particular demonstrate that and illustrate that you're not only needing to look internally for talent, but also externally. What opportunities do you have in the United States for individuals, and what opportunities abroad? Ultimately, what it comes down to is that you need good planning, you need good strategy, and with that becomes, having a sort of hand-in-hand relationship and guidance with your attorneys to ensure that you are aware that those individuals who may be at risk, understanding what options and opportunities they may have outside of the United States, which would both necessarily support your U.S. population that wants to work globally, but also your foreign national population in the United States of a backup plan. And also understand that you may need to staff outside the United States, just considering the concerns and limitations that we're seeing, particularly with USCIS and under the current administration and the challenges we're seeing there, which we will discuss.
So, speaking of the current administration, obviously you and everyone on the line knows that government is currently shut down. Last time we talked, it was a couple days before, and today we are currently in day 34 of that shutdown. So, Sarah, I'm curious, what effect, if any, has the shutdown had on immigration?
I think one of the positive components, if we're going to take anything positive out of this, is that the U.S. Citizenship and Immigration Services and the Department of Labor, specifically when it relates to immigration services that they provide that are relevant for most employers, there's little to no impact. I think the largest impact, which is more of I wouldn't necessarily call it an impact because there's not a violation, it's more of a general housekeeping item, is for those employers who are E-Verify, registered E-Verify compliant, you will not be able to complete the E-Verification process when you complete the I-9 like you normally would, because E-Verify has been shut down as a result of the government shutdown. However, as a result of the government shutdown, you're not able to take action. And so I think it's important to be mindful of making sure that all of those new hires that you have during this time, you definitely complete your I-9 as you would do, but also make sure to have a running tally and list of those individuals so that you can run them through E-Verify once it opens back up again. So that would be the impact. Even though it will be after the required 3 business day deadline, you're not going to be harmed as a result. The government has acknowledged and is perfectly aware of the fact that you cannot E-Verify employees because the government is shut down. And so it's just more of a housekeeping issue than it is a major impact.
Gotcha. And another question, and I know you're going to talk about this proposal later, but the H-1B proposal, I'm curious if the current shutdown has had an effect on the timing of that at all?
It's still going through the review process. USCIS has announced that it is under review, and that as of right now, the proposed policy is being reviewed as to whether or not it'll be fully implemented. All of that being said, it is the status quo. We are now end of January. CAP petitions are being filed first week of April, and making sure that you're prepared and moving forward as you would have over in every other CAP. Once we came down to the number 85,000 number is what everybody should be planning on doing. Obviously, if you have further or more specific questions based on your business need, reach out to your immigration attorneys because their advice will become critical. But generally speaking, status quo. Get things moving forward, start gathering documentation, getting your list together, and starting the process.
Gotcha. So now, kind of curious, can you discuss some of the proposed policy overhauls that we've seen the last couple of years?
Yeah, absolutely. I think probably the one we just discussed, the H-1B CAP process, where they're trying to change it into an electronic registration process versus filing the complete petition up front. Certainly, again, I would find myself under yes, this could happen, but I don't expect it to. And because it would be the first year of being implemented, and due to the very specific language that was provided in these proposals out of USCIS, giving fair warning that things could change and could potentially change at the last minute. Keeping the status quo does become very important, and particularly this year because USCIS is still hashing it out. I think we had hoped to actually provide even more specific guidance in this call versus essentially giving the same overview as we did last time. But again, while the government shut down, USCIS was fully operating. They're moving it forward, just not at the speed in which we would hope, considering the fact they're trying to completely change the H-1B cap filing process, which then relates to they're likely not going to be changing it. So there's that unknown, but just, again, given the circumstances, keeping the status quo becomes important. And I'd also, considering the current climate that we're in, the government shutdown, I think probably one of the happier proposals that I've seen out of Congress is the fact that they are trying to add Ireland to the E3 visa category. Currently, the E3 visa category is specifically set apart for citizens from Australia. It's very similar to the H-1B non-immigrant visa category, such that the E3 is a position, one, you have to be Australian. Two, the position being offered to the United States needs to be a specialty occupation. So the compliance component of having a labor condition application, making sure that the job itself requires at least a bachelor's degree in a specific field, all of those come together. One of the perks of the E3 visa category is it's a type of visa that you can actually apply for at the U.S. consulate. So Australian citizens are able to apply at U.S. consulates abroad or embassies, typically in Australia, present the E3 visa, enter with an E3 visa application, and then ultimately start working in the United States. Opening up this to Irish citizens, I think, would be fantastic. I think that, and hopefully it would very much align with the current processes that Australians see. And I think that, when we're looking at some of the challenges that we've seen out of the administration over the last 2 years, having a positive expansion of a visa category is certainly something I enjoyed seeing.
All right, now we're going to jump into a recap of basically 2017, 2018, and these are some key policy changes that were made in coordination with the Buy American, Hire American executive order. So, Sarah, I'm wondering if you could kind of walk us through what our attendees see on the screen here.
Sure. So, I guess turning back to the reality of the situation, and, while I do like being glasses half full, we went through under this administration. It's, again, I think disruptive is a good word, and sort of putting in place an environment where with a lot of policies and procedures and changes coming out at a fairly rapid clip, we are looking at a foreign national population, particularly, or even though individuals are in the United States lawfully in employment-based status or even student status, there's a lot of uncertainty because we seem to be getting these policy guidance or mandates that potentially impact an individual's ability to remain in the United States. Probably the biggest one would be the travel ban, and that is alive and well, currently being implemented and currently impacting those individuals from the 7 listed countries that are on a varying level not allowed to enter the United States. Obviously, it's been around, so we're used to it to the extent that one can be used to prohibiting individuals from specific countries from entering the United States. But it certainly is there, and the impact from a business standpoint really does depend on how, where your employee population is. When the travel ban came out, I think one of the bonuses of having a good and advanced technology is being able to identify those employees who it could impact. I think one of the frustrations that businesses took out of this is particularly for your multinational corporations, you're looking at individuals where you've got entities all throughout the world. You may not know that your that that at your UK branch you have a citizen from Iran working, and that citizen from Iran's position, he or she wouldn't necessarily have permanent residence or UK citizenship yet to be able to enter the United States, and a part of his or her job responsibilities could be coming to the United States for meetings, and not being able to do that or having even bigger hurdles to be able to enter the United States as a result. I think that's where the pain points have really come in for businesses, and that's where identifying and understanding where your employee population is and how it could potentially impact companies, business needs, and quite frankly, mentalities of corporations. I know that a lot of companies throughout the United States that are multinational, the philosophy is, look, we're a global company and we should collaborate globally. Obviously, the travel ban could impact that. So it's looking at, again, the nitty-gritty individual level impact and also the higher level impact of how does this fit in with our corporate policy and how do we make arrangements around it. We also have had some other policies that have come out. I think, let's go glasses half full again. NAFTA is sticking around. It's just going to have a different acronym. So USMCA. For everything that we can tell, the TN visa category for those individuals who are Canadian or Mexican will be around. It's a little more restrictive than the E3 visa category or the H-1B1. There are a specific list of professional categories that actually fall under the TN visa. Certainly reach out to your immigration counsel to discuss options if you've got a Canadian or Mexican population where you would like to proceed with work authorization in the United States. And yes, the STEM OPT program. STEM OPT program is an additional 2 years of work authorization for individuals who have graduated from U.S. institutions in the United States in a STEM degree category and who are working for an E-Verified company. This additional 2 years obviously benefits considering the fact that the H-1B cap has been exceeded over the past several years. But there are very specific requirements. In the past, the STEM program was simply the foreign national employees filing their application, no employer involvement. When they extended the STEM to 2 years and put in a formalized process, employers are likely signing documents, I-983, and working more closely with the students to ensure compliance. So it's definitely important to keep track of those STEM, OPT, EAD, foreign national employees so that you can ensure compliance, particularly when it comes to job changes or separation. And finally, this is sort of an even-keeled announcement out of USCIS with notices to appear before an immigration judge known as NTAs. There was an announcement that USCIS was going to start implementing those across the board, which would have gone outside for both family-based and employment-based visa categories, which would have gone and extended typical practice, process, and procedure for USCIS to actually extend those to employment-based non-immigrant visa categories for denials. And while that has been announced and while USCIS has been directed to proceed with finding that policy for the time being has been put on hold. No such change has been implemented at this point. We are still currently watching this. It's certainly a hot button issue, but at this point in time, nothing has changed. So I'm going to take that as a positive as well. I think probably everybody's experienced the next couple of items and the frustration that comes along with it, both from an employee standpoint and an employer standpoint. We've just seen the increase of requests for evidence skyrocket. We've seen the logic and reasoning behind some of the RFEs to not necessarily align with past practice, and have had to work very hard with employers to ensure they're doing everything we can to effectuate a positive result. We've also seen the cessation of premium processing. In particular, I think the biggest impact is for change of employers. Considering the current environment of immigration in the United States, probably one of the biggest struggles for employers is movement of foreign nationals, particularly in the H-1B visa category, whereby typically And in the past, a lot of H-1B employees would change employers upon filing of the H-1B petition with USCIS. Now, the general trend is that H-1B employees with a change of employer will not start until after that H-1B has been approved. By putting premium processing on hold for these particular H-1B visa petitions, it's slowing the workforce and movement of the foreign national population and down in the United States. And that whole idea of having a mobile foreign national population is pretty much put on hold, unfortunately. Now, there are certainly some employers and employees who are going to proceed forward, but based on what's currently going on, most employees are risk averse. And in these situations, I think we can all understand why. And finally, in this particular subject matter, the H-4 visas. Certain H-4 visa holders, spouses specifically of H-1B employees, are eligible to apply for work authorization. So the current administration has repeatedly stated that they will be getting rid of the H-4 employment authorization opportunity. To date, nothing has happened. We hope that will continue, and we are currently monitoring that situation on an ongoing basis, much like all others that are still to be determined.
Gotcha. And in this slide, and this leads perfectly into our next section, the current RFE trends, denials. So as our attendees take a look at the screen, and they're going to see the percentage of RFEs, it's increasing.
Yes.
Can you talk a little bit more about, I guess, just in general, why, and maybe what steps may be taken?
Right. So I think at the end of the day, what we're seeing is just a general trend and shift in attitude to align with the current administration's take on how to look at immigration. It's not that by default you are walking into this where you would reasonably expect an approval in a position that is traditionally one that it requires at least a bachelor's degree in a specific field, and that foreign employee has one, kind of shifting that paradigm, which would be very straightforward, and even straightforward situations, not having the decision that you would expect. And I think that ultimately comes down with that first bullet point. USCIS they're given much more and greater discretion and authority. Every policy, well, not every, but most policies that have come out have been with the intention of inserting in scrutiny into every visa classification and not having and taking what would necessarily be a straightforward process where you wouldn't blink an eye, being one where you're going to do everything you can in an effort to attempt to avoid any request for evidence or potential denials.
Mm-hmm. And then on this screen here, just kind of laying out how from Q1 FY 2017 to Q4, mm-hmm. The H-1B RFE rate has increased by a lot. I mean, 17.3% in Q1, and then Q4 almost 70%. Mm-hmm. So as we move along here, what do these numbers mean for employers?
Well, I think, on a grander scheme of things, it just means more work for everybody. And I think that that's sort of general and generic. I think that preparing and understanding these issues is just going to cause more work. But again, that's generic. What it is going to come down to is longer wait times and most likely a more nervous foreign national population. Potentially more money is going to be spent. So going back to the very beginning of this conversation, we were talking about concerns, but there's also going to be a cost. That cost is monetary, but that cost, is also time and effort. And again, making sure that, not only those individuals who you report to, helping them understand why the additional costs are going up from an immigration program that used to have from immigration programs that are robust, that typically have very consistent spends going up, making sure that you can have that conversation, and then also at the same time making sure you can have the conversation with employees to make sure that you are providing them with as much support as possible in an uncertain environment. And so it really comes down to the holistic approach of what these numbers mean: instability, more money. However, that's where educating yourself, reaching out to your attorneys, making sure that you are getting the support that you need and from your immigration attorneys becomes a critical component of the success and getting the support that you need. Look, this is a stressful time, but when it comes down to it, reach out to those individuals who can help support and provide guidance. That's what you can do, and that's probably the first step if I were recommending any actions. But also, good practices. A lot of the employers that we work with have amazing job banks, and they make me so happy from an attorney perspective, where we've got very defined levels of, here's your entry-level position all the way up to a senior management level position, degree requirements, experience requirements. All having that job paradigm put together is absolutely helpful to your immigration attorney. So if you've got it and you've got that leveling and you haven't shared it with your attorneys, I would absolutely do so. But also looking at the job descriptions and really explaining what's going on. Certainly as an attorney, I can look at a job description and say, all right, this job description likely falls under a software applications developer position. However, having the subject matter expertise to write the job description and understand that, well, this one job duty actually has a multi-layer effect, and within the industry, a simple sentence might make sense to those job applicants, but in the real world, well, not everybody's a software engineer. Breaking it down into 4 or 5 is certainly a good way of doing things. Really flesh those out. That will help or should help the process, just going and explaining everything from start to finish. And certainly, even if you've done everything you can, you've done your due diligence, you've added in the additional evidence, in this day and age, RFEs are common and they can happen. And so now, instead of being shocked by receiving one, know that you're going to need the support to respond to them. I think probably the one RFE that has been consistent and continues to be a thorn in everyone's side is a specialty occupation RFE. Specialty occupations are very clearly defined. A specialty occupation is one that requires at least a bachelor's degree in a specific field, and that the foreign national that you're sponsoring has a degree in that related field, or in that specific field, or related field. There are multiple ways and variations to prove it, and generally speaking, employers, particularly those with long histories in engineering, IT, science, publishing, all have very, very clear set paradigms and requirements for their positions, where you would read the job description, you would look at the individual's background, and you would say they're going to qualify, and they do. However, again, when you have a 200% increase in RFEs and a 40+% increase in denials, you could potentially find yourself in a situation where, despite the fact that there is qualification, you're still going to receive that denial. It's probably one of the most frustrating parts about practicing immigration law at this point in time, and the specialty occupation RFE is the culprit. So certainly, again, it just goes back to reiterate that you've got to do your due diligence, gathering the information, being prepared, having honest conversations, but doing everything you can to effectuate that positive result. I think the next two, in-house employment and also off-site employment, it's very curious. So USCIS has definitely scrutinized off-site employment a lot, but now they're also having and going back to employers to verify that you actually need to employ them, or to need to employ these H-1Bs. So it's not only looking where you might place individual employees at a third-party work site to fulfill contracts, but also if you have someone just simply working for you, justifying that you can afford them and why they're there. And so we're kind of looking holistically at, you're not going to be able to find your way out of being or receiving a request for evidence because they're going after every angle. And again, goes back right to the increased level of scrutiny out of USCIS is fully supported by the current administration. So what does it mean?
Now we'll look at the head of 2019.
I think everyone can probably expect and anticipate that RFEs and denials will continue to increase. I'm hoping that they've leveled off or plateaued, where we're going to keep some fairly consistent numbers that we've seen from the growth under this current administration. However, what that will really come down to is the policies and the executive orders that are coming out of the administration, and what mentality they have, and whether or not Congress acts. I know I'm jumping down to my bottom right corner, but whether or not Congress acts. We've talked about a couple of policy changes. We've talked about some legislation. I don't expect huge changes in immigration law. I think that primarily everybody's focused in on opening the government back up right now, which would be good for everybody. But also then we're getting ourselves into, depending on when the government opens up, people starting looking forward to the 2020 elections. And so we find ourselves halfway through this current administration where there have been a lot of changes that have occurred, not through the passage of law, but through the implementation of policies. And so it's something that I would expect that general trend to continue on as well. When I'm looking at going abroad and advising my clients' employees on traveling internationally and what to expect, the general trends of delayed processing, typically known as administrative processing when you have foreign nationals applying for visas abroad, expect that to continue. That goes hand in hand with protecting America's borders, and quite frankly has been around, administrative processing has been around and part of the process for quite some time. However, it just becomes more and more noticeable when you see scrutinies increase. And the major hope that I have is, one, I would hope that USCIS is going to open up premium processing as stated on February 19th, but I wouldn't be shocked if they extended it. But there is a hope that let's clear some of these cases out for individuals before the cap opens up and the like. But I also then, on the flip side, would expect that premium processing wouldn't be available for next year for the cap cases. So I think we're gonna see this general routine. Now, is it something that I necessarily understand? No, because if you look at it and say 50% of the H-1B cap petitions are filed now with the even higher premium processing rates, it's a lot of money the government is not accepting, but that's their decision to make and their budget to manage.
There you go.
So there you go.
There you go. And as we end the main presentation there, I'm going to hop into some questions,
Sure.
Which we've been receiving throughout our time. So first question for you, Sarah. Do you anticipate an increase in I-9 audits in 2019?
I do. I think, generally speaking, you're going to look at I-9 audits. I think USCIS site visits will continue and increase. I think that if there's one general rule of thumb, one that you should always have, good housekeeping, right? Extends not only from where you live to also where you work, particularly from a compliance standpoint for when you employ foreign national workers. So putting an audit process in place for your public access files, your perm audit files, your I-9s, making sure that you've got trends and reaching out to your immigration counsel to establish these practices and procedures is an excellent idea. It's a new year. Set goals and work on implementing those goals. Gotcha.
And then moving on to our next question, what are some common reasons, I guess, for H-1B denials with such an increase that you've seen?
So I think there's an increase in denials, again, going directly back to the increased scrutiny that we're seeing, the increased discretion that USCIS officers have and how they are reviewing and analyzing what it means to be an H-1B specialty occupation and then also to have an H-1B employee that qualifies for that H-1B. I think that the standards of adjudication, while the law remains the same as how you prove, the standards have shifted slightly, such that even if you have a very straightforward H-1B, you're still potentially looking at a denial. Most recently, I had a denial come through where USCIS mentioned that that an employer hadn't gone back almost to the 1940s to demonstrate that they've always asked for a bachelor's degree. I mean, I think that you're looking at a reasonableness standard here that we've not seen. And so just being prepared, really working with your your immigration attorney to get the evidence that you need, and being as creative as possible to demonstrate why the positions that you're offering from an H-1B standpoint, will be approved, because that's obviously the goal.
Yeah. And I think I know the answer to this,
right.
But if someone wants to know more about the basics of employment sponsorships, where can they learn more? Where can they extend that knowledge? And
Well, GA and Envoy have worked together to put a lot of great information on Envoy's website and platform, just to provide general overviews of what particular visa categories mean and how they can be utilized by employees and employers for that matter. And so that's where I would start.
Perfect. And as we kind of go through some of our other questions, just want to mention that there are some more webinars coming up where if you do have some more specific questions or would like a refresher on the H-1B cap season, we do have another webinar next Tuesday. And then our final one in January, you can learn more about how technology can help your rapidly growing company scale. Additionally, follow us on social media. That's our plug. And then for everyone in attendance as well, we also have SHRM and HRCI activity IDs. So as we kind of wind things down here, we're going to just extend a big thank you for everyone in attendance. And again, the slides and the recording of this presentation will be emailed out to everyone tomorrow afternoon, so please keep an eye out on your email inboxes. Again, thank you for attending. Sarah, thank you so much for the informative presentation. Very helpful.
Thank you.
And I hope everyone has a great rest of their day in addition to a great weekend.